Right, so why are you beating up on a 14 or 15-year-old? And you came up behind her, pulled her by her hair, dragged her by the hair, and punched her. So I'm trying to figure out why are you hitting on a 14-year-old? So are you saying that this is just all made up?
Uh, oh gosh.
There's a video according to the police report.
I know there's a video. I know it's a blurry video. I know it looks like me.
Yeah, it's saying that you pulled her hair, you beat her up.
No, I'm aware of what she said I did.
Today's defendant walked into the courtroom looking completely unbothered. Her head was held high, her confidence never wavered, and she carried herself as if she already knew how this was going to end. There wasn't a hint of remorse on her face, just the belief that she could explain away everything she'd done. But she was about to learn a lesson the hard way. This judge doesn't reward attitude, excuses, or empty confidence. In this courtroom, every decision has consequences, and those consequences can include time behind bars. As the hearing begins, the tension is impossible to ignore. Everyone in the room seems to sense that her confidence is built on shaky ground. It's remarkable how easily some people convince themselves that violence is justified, right up until they're standing before a judge, forced to explain their actions under the bright lights of a real courtroom. This isn't scripted television, and there are no second takes. Every word matters, every answer counts, and the outcome could change her life in an instant. Then comes the moment that changes everything. The judge starts asking the questions she clearly wasn't prepared for, peeling back every excuse one layer at a time. Suddenly, that confident attitude begins to crack, and the reality of the situation starts sinking in. Will she stick to her story, or will the pressure finally expose the truth? Let's dive into the courtroom and see exactly what happens.
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison? Counsel, has your client been able to provide you with any defenses?
Yes.
Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is recommending deferred adjudication. There's an affirmative finding of family violence, no contact with Ariana Garza. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
Next, I'm showing you outside the agreement. The state is recommending that your community supervision be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State offer states one and attachments.
We did review them, no, Judge.
Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you might want to say on behalf of your client?
Judge, there are several things. She's 33 years old. This case happened about 3.5 years ago. Since that time, everything's been perfect. It's happened to be the girlfriend of her son, who she thought was leading him down the wrong path. Certainly not handled correctly, but the boy does not date or see the girlfriend anymore. Mom has not seen this girl since that time. She does have full-time employment as a night auditor of a local hotel. She is gainfully employed. She does other side work with other groups that she can tell you about if you'd like to hear, because I'm not familiar with the groups that she works with.
So how old was your son's girlfriend?
At the time, my son was 15, so I was swimming around 14, 15.
All right, so why are you beating up on a 14 or 15-year-old?
I'm not the one who did it.
I'm sorry, what?
I didn't. I've never seen this. Like, I've seen the girl in person, but I've never.
Now, according to the police report, what you just pled to, she was walking with your son in a park and you came up behind her, pulled her by her hair, dragged her by the hair and punched her. So I'm trying to figure out why are you hitting on a 14-year-old? I'm sorry, what?
I mean,
There's a video according to the police report.
it's I, hmm. I know there's a video. I know it's a blurry video. I know it looks like me.
So are you saying that this is just all made up?
Oh gosh.
No, if you want a jury trial, we will give you a jury trial.
I mean,
How do you reach your 40s and end up accused of attacking a 14-year-old girl, your own son's girlfriend, simply because she was dating him? If that's really what happened, it goes far beyond being protective. It's a decision that's incredibly difficult to justify. Now she's sitting in court, stumbling through excuse after excuse, sounding like she's trying to build a defense on the fly because none of it seems to hold together. And with the incident reportedly captured on camera, there's very little room to argue about what happened. What stands out just as much as the allegations is her demeanor. She appears completely unfazed, carrying herself as though this is all one big misunderstanding instead of a criminal case with serious consequences. Meanwhile, the judge's expression tells a very different story, one of disbelief, frustration, and a clear expectation that she's going to provide real answers. The problem is, those answers never seem to come. Every pause grows more uncomfortable, every excuse sounds weaker than the last, and the silence begins to speak louder than the words. In a courtroom, failing to respond doesn't make the questions disappear. If anything, it only draws more attention to them. She may be hoping the pressure will somehow fade away, but accountability doesn't work like that. The judge is determined to get to the truth, and that moment is coming fast.
I don't want it to go bad and make it, and I go to prison for something I didn't do.
Well, here's the thing. If you're saying you didn't do this and you want a jury trial, then guess what? In the 187th, I will put cases to trial and we will give you your jury trial. But what I'm reading in the police report, there is a video. And yeah, it's saying that you pulled her hair, you beat her up.
Yeah, I'm aware of what she said I did.
So your only question is, do you want a jury trial or not?
I don't want to do a trial.
All right. So then we're back to the point. Why are you pulling on a child's hair?
So I don't know. I was angry. I was really, really upset. My son wasn't going down any wrong path until he met this girl. They were doing drugs. He was running away. He was stealing cars. I was just trying to be a good parent.
Well, I mean, how is it a good parent to beat up somebody who's dating your son? Why do you think that she's in charge of your son's actions? Did she put a gun to his head and say, do these drugs with me?
She told my son she was pregnant.
All right. Then people need to start supervising their children better.
That's true.
I'm going to sentence you to 6 years deferred adjudication. There's an affirmative finding of family violence, no contact with Ariana. That's Ariana Garza. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular UAs. No unsupervised contact with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once she's completed parenting classes, that will be deemed satisfied. There's to be field visits, one time per month for 3 months. And there's to be 30 days in the Bexar County Jail as a condition of probation. Is there anything else you need, Luck?
Judge, as far as the 30 days, since that was not part of what we had anticipated, can she either have time to turn herself in Friday or do weekends?
No, they don't do weekends anymore at the jail.
So I got to go to jail for 30 days.
Yes. 054 State versus Angel Montoya. Can I have parties announced for the record for the state,
For the state of Texas,
for the defense?
Attorney Bill Simmons for defense.
And are you Angel Montoya?
Yes, ma'am.
Did you review the document entitled State's Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Community Supervision?
Yes, ma'am.
Are you the same Angel Montoya who's placed on deferred adjudication in 2022 CR 0054 for the offense of injury to a child bodily injury on February 13th, 2024 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, off of states supplemental pending motion, adjudication of guilt and revoke probation. Violation condition number 4. In Bexar County, Texas, the defendant, Angel Montoya, did then and there fail to report to the supervision officer as directed for the months of April, May, and June 2025 in violation of condition number 4.
How do you plead to that? True or not true? I'm sorry?
True, sorry.
Additionally, Your Honor, on the state's original motion to enter adjudication of guilt, state will waive all of those violations.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, and
Yeah.
that is for the motion to be denied to allow the defendant to apply for felony drug court. Should she be accepted to that, then fine. Should she not be accepted to that, then alter and amend conditions of her current probation to add SATIF followed by SATIF aftercare.
I
This
don't
has to
want
be
it
one
to
of the
go
most
bad
bewildering
and make
courtroom
it, and I
moments
go
you'll
to
see. The
prison for
judge
something I
asks
didn't do.
straightforward
Well, here's the
questions,
thing.
yet the defendant
If you're
offers
saying you
very
didn't do
little in
this
response,
and you want a
leaving
jury
long,
trial, then
uncomfortable
guess what? In
pauses
the
that only make
187th,
the tension grow.
I will put
Instead of
cases to
showing
trial and we will
urgency,
give you
she
your
appears
jury trial.
strangely confident,
But what
as though
I'm
she
reading
doesn't
in the
fully
police
grasp how
report,
serious the
there is a
situation has
video.
become.
He was running
But
away,
that
he was getting
confidence isn't
cars.
about to last.
I was just trying to be a
Then
good
comes
parent.
the explanation.
Well, I mean,
She
how's
says
it a
she
good
was
parent to
protecting
beat up
her son. The judge
somebody
immediately begins
who's
testing
dating
that
your
claim,
son?
making it clear that
Why
harming
do you
another
think
child
that
is
she's
not a
in charge
simple
of your
defense
son's
to fall
actions?
back
Did she
on.
put a gun to
As
his
the
head and say,
questioning
do these drugs
continues,
with
I
me?
the gaps
told
in
my
her
son she was
reasoning
pregnant.
become harder and harder to
All right.
ignore, and the confidence she
Court
walked
will
into
find
court with
violation of
starts to
condition number
disappear.
4 true. Is there a
Everything changes
proposed
the moment
agreement?
the
There is, Your
possibility of
Honor, and
30
that
days
is
in jail
for
is
the motion
mentioned.
to be
The
denied
composed attitude
to allow
begins
the
to
defendant
fade,
to apply
replaced
for
by the
felony drug
realization
court.
that this isn't just
Should she
another
be
argument,
accepted to
it
that,
has real
then
consequences.
fine. Should
In a
she not be
courtroom,
accepted to
excuses
that,
carry very
then
little weight when they're
alter and
measured
amend
against
conditions
actions.
of her current
And as the
probation
hearing
to
unfolds,
add
she's forced to
SATIF
confront that
followed by
reality in the
SATIF
hardest way
aftercare.
possible.
All right. Why isn't she reporting?
Your Honor, is the court inclined to hear testimony? Because I have one witness as well.
Yes, I want to know why she's not reporting.
If I, could- and then we'll call her, Judge.
Sure.
Okay. If I could call Leslie Banderas.
Right. Hello, could you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Leslie Banderas.
All right. Counsel, you may proceed.
Ms. Banderas, how long have you known Ms. Montoya?
All right.
All her life. And you're familiar with her legal situations that she's been involved with, correct?
Yes.
Okay. And you've got a unique knowledge of that based on some of the organizations that actually, community organizations, the numerous community organizations that you're involved with, correct?
Yes.
And what are some of those organizations?
I have organizations called Homies and United Network,
Mhm.
how we deal with the formerly incarcerated and their families by, providing resources or guidance into the right direction.
And the reason I'm asking this is that so that you have some understanding of Ms. Montoya's, what she's dealing with.
Yes,
And so you admit you deal with the formerly incarcerated.
yes,
When she had gotten out, she was on a parole, is that correct?
yes,
And but she did, bottom line, you deal with a lot of people in these situations, correct?
yes,
Would you say that she was putting her best foot forward to try to be in compliance with her parole and the new probation that she had received?
yes. From what I saw, she was completing, going to classes, and correspondence with her probation and her parole officer. We were even getting visits. She was getting visits to homes. So as far as I know, they were good visits, as far as I'm going over there.
I'll pass the witness.
Any questions?
Just a few questions. I'm sorry, I didn't catch your name.
Leslie Banderas.
Ms. Banderas?
Banderas.
Balderas. And how long did you say you've known Ms. Montoya?
I've known her all her life.
of her life. So since you were children, you guys grew up together, I guess?
I'm her mother.
Oh, you're her mother. I'm sorry. I didn't hear that part too. All right. So you being her mother, are you aware of the issues she's been having with substance abuse?
Yes, I've been aware as far as what she was I guess smoking.
Okay, how, to your knowledge, how long has she been abusing drugs or smoking, as you said?
I'm not even gonna lie to you, when my kids didn't even start messing up their life after they moved out of the house, after the age of 18.
Okay, so-
She's always I've never had problems with her in school, anything like that. She graduated, even had a scholarship to go to college.
Mhm.
She was good, so.
All right, so after adulthood is when these issues started to come about.
Sorry to
Yes, when
interrupt.
you-
So, sorry to interrupt. You're recommending that she be continued?
Correct.
All right, so here's my question for her. Either she wants to be on probation or not. She's not going to be released today. She's going to safety. If she doesn't want to go to safety, then she's going to be revoked.
Oh, I believe the recommendation was SATIF, Your Honor, or no, safety.
It's sad, but based upon the stipulations that were entered into and what she did, obviously there are major drug issues, and this is more than just, I think, can be taken care of by SATIF, because let me just tell you the reason why I say that. She's looking at 10 years in the prison. She has some choices to make. Either I use drugs, and potentially could go to prison for 10 years, or either I don't. And she made the choice, I'm going to use. So that tells me that her thought processes are not where they should be, and that she's in the throes of her addiction. So I'm going to give her a choice of whether she wants to be continued on probation and go to safety, or whether she wants to go to prison.
What is that, CFP?
It's an inpatient treatment facility at the prison.
Oh, and they provide housing, because me,
Yes, they do.
what, like I said, the organizations that we do, we just feel, they need help regardless of what.
No, they're gonna give her help.
Regardless of what the case is, every individual needs help.
No, they're going to give her help if she wants it. So let me have you step back, and I'm going to ask her what she wants.
Then the case takes an even more serious turn. During the hearing, the discussion shifts to her own alleged substance abuse issues, even as she claims her actions were meant to protect her son from a bad influence. The contradiction is impossible to ignore. It's difficult to convince a judge that you're acting in someone else's best interests when you're being questioned about your own struggles. The judge picks up on that inconsistency immediately. The questions become less about excuses and more about accountability. One after another, they're designed to uncover the choices that led her to this courtroom in the first place. With each answer, the confidence she arrived with seems to fade, replaced by the weight of facing the truth. At this point, the case is no longer just about punishment, it's about whether she's willing to change. Programs focused on substance abuse can offer a path toward rebuilding a life, but only if the person involved is prepared to take responsibility and commit to the process. If that opportunity is ignored, the consequences become much harder to escape. The real question now is whether this courtroom will be the beginning of a turning point, or just another stop on the same destructive path.
Your Honor, so we're saying that there's no option for her to at least be interviewed by a felony drug court?
Felony drug court is probably not going to accept her. I'd say 98%, because of these charges and the underlying facts that are in these stipulations. So you have a choice. If you want, and these are your only two choices, there are no other choices. So there's no third choice. One, I can continue you. I will continue you and sentence you to safety. Or two, I will revoke you and sentence you to 5 years in the prison.
Okay, but that interferes with my parole that I'm already on. And I'm good on parole. I go to all my classes, I pass all my drug tests, even some of the drug tests that I've come out negative as far as on probation, I've passed on parole. I'm getting help. I go to behavioral therapy, I go to therapy, psychiatrist, I'm on my depression, anxiety pills and everything like that. I'm on a mood stabilizer now that I'm in Bear County.
See, these are things that people need to do when they're not in
I
custody.
was doing that before custody. I have proof that I was doing that before custody. I went to university, I got into behavioral classes, I got into therapy. When I went to my TAP evaluation, I asked for the intensive
Mhm.
outpatient drug course because I told her I felt like I needed the help.
And if I may, Judge, we did verify that with probation. She was only one class away from intensive outpatient, but I think the big thing is that they wrote her glowing reviews. They said she was doing a very good job.
Mhm.
That's in the notes. It's also reflected in the court summary.
Any
In terms of
objections
that
to
she
the
was
court
doing-
reviewing the court summary?
No, Your
From
Honor.
the state.
All right, in reviewing the court summary, it says that once she just found out she had a warrant, she didn't report anymore.
Yes, Your Honor, I believe, but it's also under the, if I could see it. Up with this. What I was just specifically referring to was in their justifications. Just that specific language
All
about.
right, so what I'm
despite
telling
the,
everybody,
Their great attendance in the IOP program.
all right, so this is what I'm telling everybody. They 99%. There's a 1%, maybe they'll accept her in the felony drug court, but there's a 99% chance they are not. What I'm telling you is she has a choice. If she would like for me to revoke her, I will sentence her to the 5 years. If not, then, I'll send her to felony drug court, but I'm telling you, felony drug court is not going to accept her. There's a 99% chance they won't accept her. If they don't accept her, she's going to safety. So those are the choices. There are no other choices.
Yeah, I understand this.
So, can I have 30 seconds, Judge?
Yes. Counsel?
Yes, Your Honor. If we could, about how long do we think the felony drug court referral would take? Because
They'll probably have it done by next week.
there's some questions to ask in terms of whether or not the safety would result in her parole being revoked, because it's treated as if, and I would ask the court too, it would be treated as if she's being sent to prison, which would revoke her current parole. That's a question that I would like to know, because I'm
Well, I
not
will
putting
tell
at
you
the
that
front of my thoughts.
if
I'm
it-
not sure if that's true.
If that's true and it results in that, then
Yes.
we can always bring her back. All right, the court is finding violation of condition number 4 true. Court would deny the motion. Alternate amend conditions to include in custody, a referral to felony drug court. If not accepted, then safety.
What a courtroom from start to finish. We watched a case involving allegations that a woman in her 40s assaulted her son's teenage girlfriend, followed by difficult questions about her own personal struggles, all while she appeared determined to justify her actions. Whether she believed she was right or not, the courtroom made one thing clear: accountability eventually catches up with everyone. What stood out most wasn't just the defendant's explanations, it was the judge's approach. Calm, firm, and clearly focused on the bigger picture, the judge wasn't interested in excuses. The goal was to determine the facts, enforce the law, and make it clear that every decision has consequences. The biggest question now is what happens after the courtroom doors close. Will this experience become the wake-up call that finally pushes her toward making better choices? Or will she fall back into the same patterns that brought her here in the first place? The answer to that question could shape the rest of her future. What do you think? Was this hearing the reality check she needed, or do you think we'll see her back in court again someday? Share your thoughts in the comments below. If you enjoyed this breakdown, don't forget to like the video, subscribe for more real courtroom stories, and turn on notifications so you never miss an upload. Thanks for watching, and I'll see you in the next one.